regard to identification of the property, this was one of the issues which.
Yes, we are actually concerned.
Yes, absolutely. I'll not ask for anything else. But Your Lordship, again, few submissions would be repeated. That Your Lordship may kindly consider one aspect. That altogether 16 annas that has come in evidence.
You see, let me propose one. Right? Both of you have already argued the matter.
Yes.
Right? You will be giving your written submission.
Yes.
Please incorporate whatever you have submitted.
Exactly. This is.
And then,
after
going through the written submission, I will also brush myself.
Yes, absolutely.
And then I would give you 10-15 minutes each, seeking some clarification from your end.
This was my request.
This is how it will be done.
Otherwise, I have the keyword which is already marked as exhibit. But Your Lordship, I have certified copy of the taken out from the same record. That means from the original suit when it was pending before the trial court.
That's right.
I can demonstrate that all the keywords, they were in individual names of the persons, all the three branches, whose name time and again has come.
So that must be in the record.
Yes, it is there. It is there.
You can do one thing. I'll tell you one thing.
Yes.
Right? At the time of filing your written submissions, you can specifically refer to the exhibits you are talking about, and any exhibit which you want us to scrutinize it very carefully. And क्योंकि photocopy बहुत clear नहीं आता है कभी-कभी,
नहीं है,
right?
नहीं है.
You can annex it with your written submissions, saying that it is exhibit such and such on record. You can highlight it also. There is no problem about it. ठीक है? आप अपना एक कलर अलग-अलग आदमी यूज कर लीजिए.
हम दो चीज इनसे भी रिक्वेस्ट करेंगे. That Your Lordship, one document, two documents which is according to me important. Title suit 8 of 1941, which from the original record of 841 we had taken certified copy of the entire record. So can I give that?
Yes, there is no.
Because
it is already
that
there
is
on
already
record.
on record. So originals.
देखिए हम लोग का टारगेट है.
मतलब
हम लोग का सारा टारगेट है.
With his permission, not.
Our target is the litigant.
Yes.
Right?
Exactly.
You are also instructed. They are also instructed, and I am instructed by. बस और हमें कोई कंसर्न नहीं. ठीक है, हम ऐसा बिल्कुल भी नहीं चाहेंगे कि कुछ एरर ऑफ रिकॉर्ड हो जाए.
नहीं एकदम.
या कोई आर्गुमेंट हम छोड़ दें. इस तरह का सिचुएशन में हम नहीं आना चाहते. And I see people are staying over the property. बहुत सारी चीजें हैं. हम लोग को हर चीज हम लोग को देखना पड़ता है. ऐसे नहीं है. इस तरह से उठा पटक नहीं होता.
नहीं हम नहीं ये कर रहे हैं.
तो आप लोग अपना सबमिशंस जितना अच्छे से बनाएंगे, उतना बढ़िया जजमेंट आप एक्सपेक्ट कर सकते हैं. फ्रॉम आई विल ट्राई माय बेस्ट.
एकदम एक ही प्रेयर है that Your Lordship, few things that may be added in the written argument, which
जो आपको ऐड करना है आप सबमिशन करें. जो आपको ऐड करना है
ऐड करना है. जैसे हम चार्ट बनाएंगे. हाँ. चार्ट जो बनाएंगे
तो आप ऑलरेडी बहस कर चुके हैं. चार्ट जब आप चार्ट बना के रिटन सबमिशन फाइल करेंगे, आई विल सीक योर एक्सप्लेनेशन ऑन दैट कि ये चार्ट का क्या बेसिस है, कहाँ से आप इसको उठाए हैं, उसका क्या रेलेवेंस है. ऐसा एक दिन हमको आपके रिटन सबमिशंस में भी लगेगा. ठीक है? जिस दिन हम आपके इंटरलोक्यूटरी एप्लीकेशन सुनेंगे, उसके अलावा रादर इंटरलोक्यूटरी एप्लीकेशन सुनने के बाद आपके रिटन सबमिशन
वो बेटर.
रिटन सबमिशन में आप अपने जो भी इंटरलोक्यूटरी एप्लीकेशंस में डॉक्यूमेंट लगाए हैं, यू कैन जस्ट एनेक्स दोज वंस अगेन फॉर द पेरिसल ऑफ द कोर्ट and mention that this is through interlocutory application. हाँ, वो आप अपना कर लीजिए उसको, तो चीजें बिल्कुल क्लियर हो गई.
मेरे हिसाब से Your Lordship, that Your Lordship if would only allow us to submit our written notes along with whatever our contentions are, and then after hearing on the IAs, Your Lordship may also allow all the parties, not only.
No, I will allow it.
All the parties only half an hour each on the same day.
I will surely allow. हमको
That
इसमें
is
कोई डाउट
only
नहीं
prayer,
है.
not only.
आप लोग एक काम और कर लीजिएगा, एक काम either of you, ठीक है? Plain written statement, है ना? वो थोड़ा सा बहुत confusion है. वो आप अपने written submission में डाल.
ठीक.
और आप लोग आपस में एक्सचेंज भी कर लेंगे, जिससे कि किसी को लगे कि कोई डॉक्यूमेंट अलग से कोई डाल दिया है. ऐसे ही हम जानते हैं you will not do it. But still required है. You have to exchange amongst yourself. Maybe court proceeding के समय exchange कर लीजिए कैसे. There should not be any gap. और आप लोग से ये रिक्वेस्ट है भाई रिटन सबमिशन में जो भी लिखे फिर ये मत बोलिएगा इसमें ये एरर हो गया है, आप लोग पूरा वेरीफाई करके ठीक से समझ के लिखिए,
ठीक है,
फिर बाद में पता चलता है कि उसमें कुछ एरर हो गया है तो दिक्कत, वो आप लोग अपना समझ के कर लीजिए। अगर आपको लग रहा है कि इसमें आपको कोई फर्दर सबमिशन और नहीं करना है तो यू कैन जस्ट पुट इट इन द रिटन सबमिशन।
it would be better that everyone is heard post IAs, post hearing.
हाँ, we will hear your written
That would be a
submissions
better option
on the
because-
written submissions post IA,
हाँ,
ठीक है, IA की हियरिंग हम कर लेंगे,
हाँ ठीक
है ना। तो क्या ऐसा भी कोई इसमें एडिशनल डॉक्यूमेंट है which was not within your knowledge? ऐसा कोई इसमें
है, which was at least one of the IA which I have filed 2 IAs. So one IA which I have filed, that everyone has referred to title suit number 26 of 2003. They have brought plain everything, the order sheets, everything. That ultimately ended in a compromise between us and Dattas, and the terms of compromise would be very relevant.
you and Dattas also entered into a compromise?
Yes, that is the reason I say. So
Whatever.
So what would be the impact of that understanding? And that was entered in 2016. The first appeal is of the year 2012. So that would have
That is
an
a
impact.
subsequent development.
Yes. So that occurred during the pendency of the first appeal. So what would be the consequence of such admission?
And I hope all the parties have exchanged the interlocutory application. Last में कोई आके ये नहीं बोले कि हमको ये IA का कॉपी नहीं मिला, I want to reply.
That is also we have supplied. If anybody says, they will say it now, your lordship.
Yes,
That-
so that
हाँ भाई, ये फिर बाद में जो है ना कि एक तो जिसको बोलते हैं लंगी मांगा, हाँ, वो हम परमिट नहीं करेंगे।
फिर एक दिन डिले हो जाएगा।
एक दिन क्या, बहुत दिन डिले हो जाएगा। वो बोलेगा हमको 15 दिन चाहिए रिप्लाई करने के लिए।
नहीं, ये जो फाइल के अभी तो
ये सब कहानी नहीं, I will record it that all the interlocutory applications have been already exchanged amongst the parties.
हाँ,
I just do not know, कल को कोई कहानी हमको नहीं सुनाए।
Any relief somebody tries to take a relief as against the other.
I just do not know. आपको आइए मिला, आपको जो मर्जी करिए उसका। We do not know anything about it. आपको कॉपी मिला है, आपको जो मर्जी करिए।
कॉपी हम लोग नहीं ले रहे हैं।
नहीं लेना है तो मत लीजिए।
लॉर्डशिप में से
मतलब-
रिलीफ सिर्फ प्लेंटिफ को ही मिलता है और किसी और को नहीं मिलता।
अब हम इनको क्या बोले, ये तो क्या, ये तो सोच रहे हैं कि यहाँ समंदर चल रहा है, यहाँ
नहीं,
बस एक तो
नहीं।
नदी चल रहा है, बस एक तो नाला,
बस
उसके अलावा
समंदर
कुछ
नहीं।
नहीं चल रहा।
कोई किसी में थोड़ा सा कहीं
नहीं, सब
ये
होता
तो
है।
वो डर की परिस्थिति है। Otherwise-
Inter-state dispute cannot be decided in.
We would not wish to interfere. Only that's the only.
There was one IA we not having. I have told him he is giving it.
हाँ, he says that additional 2 M-forms which we had brought by way of additional evidence.
थोड़ा तो शर्म करिए।
वो
हम
दे-
पूछ रहे हैं तब आप बता रहे हैं।
हाँ,
नहीं, इनको बता दिए।
हम दे देंगे।
मतलब-
अभी हमको बोले
इनका
तो-
बात से
मतलब
निकला कैसे फाइल हुआ है?
इतना भी थोड़ा आंख में थोड़ा पानी लाइए, थोड़ा शर्म करिए।
नहीं, इसीलिए बोले इनको बोले कोर्ट को भी
अभी
नहीं बोले।
तो अभी आप एक तो रिप्लाई फाइल कर देंगे, उसके बाद एक तो कहानी शुरू हो जाएगा। फेयर टू मी?
अच्छा, हम दे देंगे। हम
इज इट फेयर टू मी? जस्ट टेल मी मिस्टर दास।
अभी जस्ट
एक एवरी डे सुन रहे पूरा सेकंड हाफ।
If the IA has been felt some.
आपको दिख नहीं रहा है लिस्ट में कितना आईए है
इनका IA
पेंडिंग?
मिला हुआ है, एक IA
हम नहीं
दो
जानते
IA फाइल।
मिला है नहीं मिला है, क्या किए हैं आप लोग, वो सब हम नहीं जानते। सारे तो लिटिगेंट यही बैठे हैं, फिर क्या सोचना है?
ले ले।
This is मतलब अनफेयर, एब्सोल्युटली अनफेयर।
Without asking for any
इतना दिन से
accommodation, I
केस
only
चल
said
रहा
that-
है, आप लोग को नहीं पता है कि कितना आईए पेंडिंग है, कितना क्या पेंडिंग है। कोर्ट विल बी आस्किंग यू इफ यू वांट टू फाइल अ रिस्पांस एंड देन यू विल we are finishing the arguments today
Yes.
and then you say एक तो आईए हमको नहीं मिला है, इसका हम क्या मतलब निकालें?
हम लोग को जितना IA मिला हम लोग रखे हुए हैं।
हम नहीं
And
जानते मिला है,
जिसको
नहीं
रिप्लाई
मिला
करना रिप्लाई कर दिए। एक IA भी मरमन से पता चला तो हम वेरीफाइड देन आई सेड दैट वो IA हमको नहीं मिला।
है। इसीलिए तो
किस
बोलते
IA का
हैं
क्या कंटेंट?
ज्यादा बिजी रहा करे तो किसी और को बहस करने के लिए दे दिया करिए, नहीं ऐसा करिए लिटिगेंट के साथ।
But I will not take any additional time. I will not seek any additional accommodation.
Just
What is there? We will argue it on that. On the face of that document, we will argue it.
क्या करना बोलिए। और आप
Your Lordship may post it on Monday.
ठीक है, आप लोग रिटन
Complete
सबमिशन बना दीजिए,
written
फ्राइडे को दे
submission
दीजिए। आपको जो भी देना है
and your lordship,
reply argument. My reply argument.
हाँ
एक ही साथ होता, that would have been better. Otherwise
कर
हम
देते हैं, so that they will know what my reply
नहीं तो
is.
हम
ये आपके लिए better.
ये अगर कंक्लूड कर रहे थे
हम तो वो पूरा चार्ट लगा रहे थे, लेकिन वो I have to, it would take some time. इसी के लिए हम इतना ही
ठीक है. Reply argument or after my submission of I can do.
दिखाई दे रहा चार्ट क्या है
then
कम से कम ये इसका तो रिप्लाई आपको
prima
करना
facie
पड़ेगा ना
हम
हाँ
मेरा जो ये है उतना हम कम से कम कर रहे हैं. This is the certified copy from the title suit, so it would help your lordship in deciding. हम दे देंगे ये चार्ट दे देंगे. हाँ receipt. Your lordship may I'll pray that your lordship would also open up the scheduled property of the plaintiff itself,
Yes.
of the instant suit.
Yes. Schedule A, Schedule B.
Schedule A. That is the main property. There are in the names of 5 different persons in whose name 5 different M-forms were issued, and these properties are, portion of those properties are scheduled property. So entire property which was there in auction, sale, purchase, all those are not the suit property. Because only the portion, as your lordship would recollect, that when Sahara published a news notice in the newspaper, then that gave us cause of action because that property was
Mentioned.
identifiable with our property. So therefore, that was the reason that it matched the description of 85 acres which was there. So apart from this, there are altogether, your lordship, 454 acres of property are there. 454 is in Ranguni Mauja.
Okay.
See, that constitutes 16 annas.
16.
Now 16 anna, in 16 anna, 6 annas would approximately come to 155 acres. This is approximate figure. Now, when this after vesting, when the pursuant to Bihar Land Reforms Act, now 6 Jamabandis, one was in the name of Haribol Paul and other 5 which are here before your lordship. All those 6 Jamabandis, altogether 112 acres were.
5 was in the name of Haribol and 5 were, क्या नाम है उनका?
5 है Nirmal Kumar Paul.
Other Pauls, who are the
other
plaintiffs.
Apart from,
Who are the defendants?
they are the plaintiffs.
Paul.
Pauls.
Yes. Plaintiffs.
Yes.
Yes.
So these were from the branches of 5 different plaintiffs. All 5 branches, there in their names, the separate rent assessment cases were initiated. And separate rent assessment cases, and the rents were assessed in their individual names. So,
Under 456.
yes.
456 BLR.
It would be 5, 6 and 7.
Okay, 5, 6. That's fine.
Then Haribol Paul's property is approximately 11-12 acres. That is not here. That
11, 12 means?
12 acres approximately.
12.
Yes. That your lordship may deduct from 112. So
155.
from 155, altogether 6 Jamabandis, they only total of those 6 Jamabandis was approximately 112. So other properties were vested in the state.
6 Jamabandis, they constituted 112 acres.
112. So rest vested with the
6
state.
Anna constituted 155 acres.
55, but
6 Jamabandis, they constituted 112
112
acres.
because rest
and the
vested with the
remaining,
state.
they vested with
Either
the state.
it was Sarat, whatever it was, common land was there. So only Jamabandis, those were recognized, were approximately 112, out of which
Haribol's
Haribol's
12.
property is approximately 12 acres.
100
and
acres.
100 acres. Now, 100 out of 100 acres, certain properties were acquired by the BCCL,
Part acquired.
part acquired, and part which was left is still a property over which the one of the title suit of 26 of 2003 was there, and this particular property of 85 acres, because this only matched the description of the property, therefore we only filed a suit with regard to 85.
85.
So
So
therefore,
their contention that there were other properties also is correct.
other properties?
Yes, because other properties, you say in para 3 of your
No, not with regard to that. They say that it was Datta's property,
Achha,
other
Datta's
property,
property. Okay.
not my property.
All right. That's right.
So they say that is with regard to Datta's property, there were other properties.
Now, part of this 100 acre
Yes.
is the subject matter of title suit number 26 of 2003,
Yes.
which ended in a compromise.
And in that compromise, Datta's in 2016, very clearly they admit that, I'll read out that paragraph. One paragraph is absolute.
This compromise is exhibited
We have filed because it was
through IA. It
through
was
IA,
subsequently done.
certified one. This is,
You can just read out that paragraph
yes,
and then we can just put it in your written submission.
yes. This was joint petition for compromise, and then relevant paragraph, Your Lordship, para 2 and 3, Your Lordship, may allow. 5 in fact is the main paragraph. 5. It is specifically mutually agreed that the defendants specifically acknowledge that initially their predecessor in interest were owners of 6 annas in the entire lands of Ranguni Moja, which was subsequently acquired by predecessor in interest of the plaintiff in auction conducted by the court of Sub-Judge Dhanbad in multiple suits and execution cases thereon, by which they became absolute owners. So they very clearly.
This is a compromise between you and Datta's?
In 2016. Yeah, additional.
And Datta's are not the applicants before us.
Yes, that is the reason I say. Now what would happen? That now they cannot argue contrary to what they have. Firstly, there were multiple litigations against them, and they had in fact there were findings against them in multiple litigation, and in none of them they succeeded. Ultimately, they have acknowledged this although in another suit, but connected to the same execution. And
I just
procedure.
want to know one thing.
Yes.
Datta's have also executed sale deeds.
Yes.
Is there any recital in the sale deeds with respect to their title? Is there any recital in their sale deeds which have been exhibited
Yes.
with regard to their title?
I'll point out that also in my submission. What has happened? That almost many of the sale deeds were executed by the same person whose own gift deed was cancelled in title suit number 8 of 1942. So if the initial gift deed was itself cancelled, on the basis of that, the persons in whose favor those transfers had taken place, they had absolutely no right whatsoever to have executed anything. So I was even not required to file any suit, because that would be absolutely a void document. So here, Your Lordship, the consequences, what would happen, that may be left. I say that here the consequences are that it is a litigation between me and them and Datta's also, where Datta's have agreed that whatever transfer was there, it was absolutely 6 annas interest only that was there, This is one admission very clear. That means apart from 6 annas, there was nothing else it was there. This is one. Second, that entire 6 annas interest we had devolved on us. And therefore, what they agreed, the agreement was that we agreed that I would allow you to remain in a portion of the property in which you have a dwelling house, and therefore that was the compromise. So once they have taken advantage of a compromise, and on basis of that, I enter into a compromise, I relinquish my right on that particular property, then that admission acts as estoppel against them.
At best, you can say that the genesis of the compromise is that particular.
Absolutely, absolutely.
At
Same.
best, subject to what they
Same. Because they very clearly say that it is the 6 annas only they had, their predecessor in interest, and entire 6 annas were auction sold. So that is not out of the blue. That is fitting into the entire circumstances which we have pleaded, and it has also been admitted by the parties in the original pleading it also.
Who is in possession?
Vacant land, almost entire land is vacant,
Still
except
vacant.
few. So what would happen to those few is a separate matter. So entire land almost, that can also be ascertained because your Lordship has called for the case records of the original execution case. So what would happen, that report is also there in the execution case. So that would clarify. If someone was there residing, then the matter would have been, what would be the effect on him? That would be a litigation when we file a suit against them for their eviction.
Therefore, this judgment will anyway not bind them.
Absolutely. If they are dispossessed, then they have right under 2197/98. So if there is only a sale deed, here the difficulty is what would happen if a person pursuant to your Lordship's judgment, let us assume that the appeal is dismissed, both assumption we must take. Let us assume that the appeal is dismissed and it is held that certain things are there. Then what would happen, that someone from those sale deeds who are not in possession, they may not come up and start claiming. I similarly, I cannot also evict those persons who are already there in possession. So this may not create
Otherwise,
a
also the sale deeds are not under challenge.
No, these are according to me, they were not required to be challenged because most of it were executed by persons who were absolutely, whose own title was not, and your Lordship would also recollect that in compensation case all these same persons were there whose own claim on the basis of those sale deeds were denied.
Very same sale deeds.
Similar persons. Because entire land was not acquired, only a portion, but all those purchasers from those persons had filed this, and what would be the effect ultimately of a litigation? Here interesting case is,
and only sale deed with respect to part of the property has been placed on record.
Part.
Not
Yes,
the entire.
Yes, part.
Only
Part.
some of the sale deeds have
Yes,
been placed on record.
part.
So statement that other portions were also sold is absolutely not supported by any.
By evidence, and there is one thing. There is one thing that there were other sale deeds also, where we were actually connected to these sale deeds by which ultimately the appellant herein had purchased, had come to the appellant themselves. So this was the portion on which I was confining myself. So there may be few other sale deeds, but actually there is absolutely many of the sale deeds are executed by the persons who had whose own gift deed was annulled by the court. Now, your Lordship, I was placing, if your Lordship would see or I can file it with the chart also.
You can file it with the chart, highlight it properly, then
Yes.
we will hear it. ऐसे डॉक्यूमेंट से नहीं पता चलेगा, पढ़ा भी नहीं रहा है हमको ठीक से.
नहीं, आज हम I had called the plaintiff himself, old man, he comes and he has taught me today itself in the morning.
लिटिगेंट से ज्यादा कोई पढ़ा सकता है क्या?
नहीं हम उसको
खास तौर पे सिविल लिटिगेशन
एक रेलिवेंट हम अगर इफ योर लॉर्डशिप सो डायरेक्ट
इवन इलिटरेट लिटिगेंट इन सिविल लिटिगेशन
है
they know much more.
Yes, absolutely. And I must acknowledge that I learned many things about Kevat and Khata also today. That clarified my thoughts. So if your lordship would kindly allow me, only few suit properties I'll
बताइए खाली डेमो टाइप
हाँ demo. Your lordship may first see Kevat number. This is Schedule A, page 13, item number 1, Kevat number 57.
Yes.
Your lordship may first see
it's
the
here.
suit
It's
property.
here. I've seen it.
First, I am trying to show it from
57.
the suit. 57. Khata number is 74. And then your lordship would find that here at page, this Kevat number, your lordship would find at page 120. ऊपर में ही पेन से लिखा हुआ है, fresh to page initial. 120.
हाँ, ठीक है.
It is Ghairabad Mali.
57. Second item है. नहीं,
हाँ.
था 57.
And then your lordship would kindly turn to, it is Ghairabad Malik, and the khata number is 74, which your lordship would see in the suit property.
खाता नंबर कहाँ लिखा है?
ये suit property का दिखा रहे हैं, पहले
हाँ,
suit
सूट
property
प्रॉपर्टी का तो 74 है.
Kevat number 57, khata number 74,
हाँ.
and then your lordship may kindly turn to this comprises of khata number 28, which is at page 114.
28.
114. 28 your lordship में kindly. This is Kevat number. 28. Kevat ऊपर में ही होगा. Page 114.
114.
हाँ.
हाँ. ये 74.
28. Kevat number 28.
26, 27, 28 सबसे नीचे.
हाँ उसमें चंद्र मोहन दत्ता
हाँ
नाम.
चंद्रमोहन.
और उसी के बाद 115 में your lordship would find page 115 शंभुनाथ दत्ता. Kevat number is 29.
29. ये तो 30 से शुरू हो रहा है. ऊपर है.
29 ऊपर होगा, एकदम ऊपर होगा. शंभुनाथ दत्ता है. लेजिबल नहीं होगा तो उसके बाद है 30 है, which is शशि बाला दासी.
शशि बाला दासी 30 नंबर.
शशि बाला दासी.
हाँ.
Then page 119.
19.
Is Kevat number 51 in the name of Chandra Mohan Datta.
चंद्रमोहन.
Then 53, same page, Shambhunath Datta.
53 शंभुनाथ दत्ता.
Then 55, Shachi Bala Dasi.
55. इतना नहीं पढ़ रहा है.
These properties, lordship, are not the part of the suit property. Only Kevat number 57 is there.
ये लेफ्ट हैंड साइड में खेवट नंबर है.
हाँ वो Kevat number.
हम बता रहे हैं वो शुरू का जो है your lordship would find Kevat at the written at the very top.
हाँ.
The first few pages are Kevat and then Khatiyan starts, Khata starts. So
Kevat
first
में खाता नहीं. देखो. Kevat में खाता number नहीं होता है. Kevat is only a tenure holder's right, the property right in the village.
तो ये जो शशि बाला दत्ता और इनका जो नाम आ रहा है ये कैसे आ रहा है?
इसमें
They are the Kevatdars.
हाँ खेवटदार है.
They are the Kevatdar
तो
tenure
इनका
holder.
कहना है, इनका समझिए, इनका कहना है कि खेवट नंबर 57 ही अंडर डिस्प्यूट.
हाँ जो इनको अभी दिखा रहे हैं
57 under
only
dispute
57 नहीं 57 और भी है बट जो दिखाए अभी वो कोई नहीं है सूट प्रॉपर्टी में एक्सेप्ट 57 which is just shown. उसके अलावा कोई भी खेवट नहीं है सूट प्रॉपर्टी में.
57 है और बाकी सब खेवट कितने
52 54 59 46 and 81 only these keywords are there.
52 है इसमें.
हाँ 52 है.
52
49 है.
खेवट
हाँ
नंबर.
खेवट नंबर.
Yes, इस पर्टिकुलर एग्जिबिट
हाँ,
में
हाँ.
है. ये
वो सब होगा
हाँ.
लेकिन बट एंटायर
कौन सा?
different keywords are there in name of different other persons
नहीं,
including
नहीं,
the
नहीं,
class.
हमें
नहीं।
सिर्फ इसी कीवर्ड से मतलब
हाँ
है
हाँ
ना।
बस जो suit
57,
property
52,
हाँ हाँ
49
तो
and
why he
54
was showing all those keywords there for?
दिखा
नहीं,
दोगे
हम
और भी
इसलिए
कीवर्ड
बता रहे
होंगे,
हैं, ये वाला जो है,
लेकिन जो हम लोग का सूट प्रॉपर्टी
हाँ
है
हाँ बस उतना ही पे कन्फाइन
सूट
कर
प्रॉपर्टी का ही हम दिखा रहे हैं।
81 भी है।
हम पहले 2 मिनट हम ये 57
May I just submit one thing? Keyword में हुजूर सिर्फ tenure holder right होता है, entire chunk of land like 400 acres, 200 acres, 30 acres और जो खतियान उससे correspond होता है, अगर keyword tenure holder का है, तो उसका खतियान अलग बनता है।
उसका खाता अलग है।
हाँ, उसमें खाता नंबर, प्लॉट नंबर है, उनको उससे correspond करना होगा। keyword नंबर 57 का ये खतियान बना और इस खतियान में ये खाता नंबर, ये प्लॉट नंबर। That is how it is to be identified.
81 है
हाँ, हाँ।
चंद्रमोहन दत्ता।
होता क्या है, your lordship, he is right, but this is khata. Now in khata, when this property is mentioned on the top right corner,
Yes.
keyword number is
Keyword
mentioned.
names is
So
there,
that is
keyword
the
number.
connection. So each keyword
Has
would
a-
have
yeah.
his connection, has connection with the khata. So it
तो
would have
इसको हम
connection.
कैसे कोरिलेट करेंगे?
हाँ,
इस document को?
हम वही चार्ट बना के हम
हुजूर इस पे एक दिन समय लगेगा।
नहीं नहीं समय तो हम लगाएंगे सूट
नहीं
है
हमको नहीं
इसीलिए।
इनको लगेगा। अभी चूंकि अभी
देखिए,
केवट
बिना
खतियान में ही
समझे-
कंफ्यूजन
I'll
हो रहा
tell you one
है।
thing.
केवट खतियान में हो रहा है चूंकि
बिना
केवट
समझे हम केस डिसमिस कर सकते हैं, जस्टिस नहीं कर सकते हैं।
वो नहीं करना है।
इसीलिए मैं
हम सिर्फ इतना इन्हीं को एक्सप्लेन कर रहे हैं। एक खेवट को निकाल लें, उसके खेवट से करस्पॉन्डिंग खतियान साथ में रखें, वो दोनों को साथ कंपेयर करना पड़ेगा।
keyword खतियान दोनों exhibited है।
हाँ, तो आपको दिखाना पड़ेगा।
थोड़ा सा समझ लीजिए।
हाँ हाँ
है ना?
ठीक है, ठीक
आप
है।
थोड़ा सा समझ
हम
के
समझ लिए हैं, लेकिन हम उसको एक बार हम चार्ट बना के कंप्लीट है।
चार्ट बना के उसको फोटोकॉपी करके हाईलाइट करके जो चीजें नहीं पढ़ा रही है ना उसका आप अपना टाइप कॉपी भी दे देंगे उसके साथ। यू
हाँ।
टेक योर टाइम राइट,
ठीक।
वो आप उसमें डाल देंगे जिससे कि अदर साइड को जब देंगे तो वो ये ना बोले कि ये गलत है या कुछ
नहीं,
है,
ठीक
कुछ
है।
कुछ चीजें नहीं भी पढ़ा
तो
रही।
नहीं, विदाउट परमिशन आई डिड नॉट वांट टू डू इट because your lordship had said that I will not accept anything from which is
नहीं नहीं ये तो इसी का पार्ट है
हाँ,
भाई।
हाँ,
ये दिस कॉपी इज मोर लेजिबल देन व्हाट
हाँ, है,
फोटोकॉपी आई हैव
कुछ अगर
रिसीव्ड।
कंफ्यूजन होगा तो आई एम देयर
तो
टू
ये
असिस्ट।
से-
हाँ,
हम
ठीक,
असिस्ट
ठीक।
करेंगे।
और अगर मान लीजिए वैसा कोई कंफ्यूजन होगा तो हम तो अपने ओरिजिनल रिकॉर्ड मंगा
ठीक
लेंगे,
है,
उसमें क्या
ठीक है,
दिक्कत?
ठीक है।
एक बात लॉर्डशिप ओनली वन थिंग आई सबमिट इस केस में हुजूर ओरिजिनल रिकॉर्ड
नहीं अब हो गया ना कहानी।
नहीं आप 4 दिन में तो आ जाए। अगर 2 दिन समय लेते हैं एक ही दिन में आ जाए। हम ओनली टू गेट द प्रॉपर जजमेंट इन दिस केस लॉर्डशिप इज रिक्वायर्ड टू सी द ओरिजिनल। इतना फोटोकॉपी हम लोग को नहीं समझ में आ रहा।
कहाँ का है ये रिकॉर्ड, कहाँ का है?
और ये धनबाद
ये सर्टिफाइड कॉपी आप कहाँ से निकाले हैं? इसी रिकॉर्ड
नीचे
से?
नीचे पहले का ही when suit was pending it seems that it
तो
was
ओरिजिनल तो वही होना चाहिए।
हाँ हाँ एकदम
हम एक ऑर्डर कर देते हैं ओरिजिनल रिकॉर्ड मंगाने के लिए,
अपने पास
लेकिन
रहेगा हुजूर के
अपने पास
है।
रहेगा जो वेरीफाई
कभी
करने के
कंफ्यूजन
लिए
होगा
हमको
हम लोग
यूज
कोई
होगा,
वेरीफाई कर लेंगे।
मंगा लेते हैं स्पेशल मैसेंजर कॉल से मंगा
second
लेते हैं।
your lordship I can file it, he may inspect it, a learned friend, this is original, otherwise जो भी है वहाँ से मंगा लिया था हमको कोई ये, लेकिन मेरे हिसाब से this is certified copy from the record room, it was taken out years
मंगा लेते हैं।
original मंगा लिया।
लेकिन उसके लिए हम लोग हियरिंग डेफर नहीं करेंगे।
नहीं मत करियो।
तो स्पेशल मैसेंजर
हाँ ये करेंगे ना,
कल आ जाएगा।
कल आ जाएगा, उसमें क्या दिक्कत है? आज जमा कराइए, कल परसों आ जाएगा स्पेशल मैसेंजर, क्योंकि बहुत फोटोकॉपी है, इलेजिबल है
Yes, yes.
डॉक्यूमेंट्स को
It is for the proper adjudication of the case. We are spending so much time. We all want that a proper decision should come in this case.
Okay, so at the joint request of the learned counsel for the parties, let the office is directed to call for the original records of the case from the concerned court upon deposit of special messenger cost by the appellant by tomorrow. ये order आप हमसे sign करना, ठीक है? ओरिजिनल रिकॉर्ड आ जाएगा स्पेशल मैसेंजर।
हाँ ठीक है।
आप कल जमा करा दीजिए, आ जाएगा सर। कोर्ट कौन सा है ये? कोर्ट भी लिखा दीजिए, डिटेल लिखा दीजिए।
हाँ।
In connection with title suit number 76 of 2006, decided on impugned order का डेट बताइए। ट्रायल कोर्ट का impugned order का डेट बताइए। ये फर्स्ट अपील का जो ऑर्डर impugned ऑर्डर है ना, बताइए।
सिविल जज प्रथम धनबाद,
सिविल
मुकेश कुमार श्रीवास्तव। Yes.
हाँ
मुकेश कुमार at that time.
बताइए।
Civil judge प्रथम first धनबाद।
फर्स्ट
15 December 2011. Dated.
एक बार इनको दे दीजिए, लिख लेंगे उसमें से। It is further agreed that calling for the record will not defer the hearing of the
Yes.
case. As a photocopy of the record
Only for
is
the
already available.
convenience of the court, Lord. We are not.
ठीक है।
It is also
और आप लोग बनाइए written submissions। आपको ये तो ये बोल रहे हैं, आपको कुछ बोलना है
reply तो हम पूरा करें।
और आपको कुछ बोलना है?
रिप्लाई मेरे हिसाब से if you would have completed only after IAS, then it would have been.
IO to Lordship has said on a separate day because now which he has argued, it was on additional evidence. I was also not ready on this.
अच्छा ऐसा, let's take it this way.
Lordship.
You file your written submissions and then we'll give you मतलब आपको हम थोड़ा ज़्यादा टाइम दे देंगे, rejoinder come your submissions and we will hear you each one of you for half an hour on each written submissions. ठीक है?
यही बेटर है।
हाँ, Mr. Das, that
Half
will
an
be
hour लगे उसको 1 घंटा लगे जो लगे
हाँ,
we'll
ठीक है।
complete it. Not irrelevant argument, only relevant on the point of law and the judgments will be providing to Lordships and what lacuna is there in his bed.
जजमेंट्स
all
तो आप
those-
जो आपको साइट करना था आप ऑलरेडी साइट कर चुके हैं। अब नया कहानी इन मत
नहीं तो अब उसको जितना बात आया है नया बात आ रहा है उसको देना ही पड़ेगा।
नहीं तो आप आर्ग्यू
अभी
करिए,
रिटन आर्गुमेंट में देंगे
ऐसे रिटन आर्गुमेंट में हम नया चीज
तो अभी तो हम वही तो करना ही चाह रहे थे। रिप्लाई में तो हम
करिए।
दे रहे हैं। रिप्लाई में तो जजमेंट देंगे।
हाँ करिए, इनका हम सुन लिए
हाँ।
जितना सुनना। According to him it can be matched and he will put it in the written argument. Matching हम लोग written argument से
Matching in
देंगे।
two ways. Matching in two ways. I may be. I'm just completing now.
हाँ।
Your Lordship, matching in two ways. My contention is that entire 6 annas they had, which was entire property was transferred to us. Maybe in fractions, but ultimately entire 6 annas interest was transferred. Second, even assuming that certain properties which were auction sold and it was not clear, then ultimately the moment rent was assessed in our name and we were recognized as a rayat with regard to under 5, 6 and 7, the moment that proceeding took place and it culminated in the issuance of M form, and M form is only a culmination. Now, Your Lordship, rent assessment takes place under 5, 6 and 7. Now, the ultimate order which is passed where it is like a decree which summary of the entire judgment. Now, when the rent is assessed, then the form M is issued. Now, final order of fixation of rent, there are two consequences. One is that M form will be issued, and the second one is that the same, on the basis of the same rent fixation, Jamabandi would be opened in the name of the person in whose favor the rent has been assessed. So that now the state would start collecting rent from the person who has been recognized
Identifying
as.
and recognizing.
Yes, exactly. So this, Your Lordship would find from the evidences of all the parties that ultimately the names of all was entered and they, with regard to all these same khatas which are also involved herein, and M-form was issued and Jamabandi was, the state started collecting rent from us. So all 5 Jamabandis which are there, all are valid as on date.
Learned counsel appearing on behalf of the plaintiffs has submitted that in the concerned Mauja Ranguni, the total area was 454 acres, which constitutes 16 ana. 6 ana would be 155 acres. Six Jamabandis were opened, constituting 112 acres. One was in the name of Haribol, and the other 5 was in the name of plaintiffs. Rent assessment case was initiated in connection with Haribol as well as plaintiffs relating to each of 6 Jamabandi. The share of Haribol was only to the extent of 12 acres approximately. And the remaining property of 115 acres minus 112 acres vested with the state on account of Sairat, etc.
Not 115 minus 112, 154.
155 minus 112,
Yes.
right? He has also submitted that part of the 100 acres which remained with the plaintiffs in connection with 5 Jamabandi was acquired by BCCL in connection with compensation was also paid, and a part of the property was subject matter of title suit number 26 of 2003, which was fought between the Pauls and Dattas, which ended in a compromise in the year 2016 by way of joint compromise. And since this had taken place during the pendency of this first appeal, the same has been sought to be brought on record by additional evidence. The learned counsel has submitted that he would, at the time of filing written submissions, he would show from the records that the suit property was identified.
ठीक है.
Right? हो गया आपका?
Yes.
हाँ.
Only one clarification. Just now we said that about 155 acres were there. Out of that, I'm just asking clarification from my friend. 155 acres to the Pauls, or the 6 ana out of 16 anas, and said that one of the Paul has 12 acres.
Haribol had 12 acres. उनका assessment order अलग है ना 12 acres का. That is exhibited.
Actual calculation I'll just.
हाँ.
415 acres in all. 415.
450.
नहीं
415.
415.
415 एकड़ किसके पास?
Total.
आप तो 454 बताए थे.
400
और मौजा का पूरा 400.
पूरा मौजा का 415 है.
415 है.
हाँ.
454 की जगह 415 लिखा.
That divided by that was 16 ana. That was if 1 ana would come to 25.94.
Approximately 26.
Yes, 26, and multiplied by 6 ana would come to 156 acres.
156
Six.
approx.
हाँ.
है ना?
Then-
6 ana is 156 acres instead of 155.
6 M rolls were, grand total was 114 acres.
ये 112 की जगह 114 acres approx.
And Haribol's Jamabandi was recognized with respect to 11.87 acres.
12 acres की जगह 11.87 acres.
So therefore the balance remained was within the 6 Jamabandis were 102.13.
102 point जहाँ 100 acres लिखे हैं ना वो 102.13 approx.
Approx, all approx.
ये जो है ये 5 जमाबंदी का है.
हाँ.
102 point.
हाँ, yes.
और यहाँ पे सूट प्रॉपर्टी में कितना है?
85 only.
Is relating to 85 acres.
Yes.
The council has submitted that the suit property was confined to 85 acres, which was relatable to the advertisement issued by Saharas.
Therefore, that was the reason that only with respect to this land, the suit was.
So, His Lordship, I am taking from the argument which has been made. From that, it is very.
just clear करना चाह रहे थे because यहाँ बोले हैं कि and the remaining property of 155 acres minus 112
ये
acres.
होगा 156 minus 114. 155 minus 112 लिखा है ना? उसको 156 minus 114 करेंगे. ये
114 नहीं.
114.
उल्टा हो जाएगा.
156
156 minus.
minus 114.
हाँ, 114 पूरा फॉल्स का.
भाई वो वेस्ट कर गया.
Then
भाई 156 minus 114 वेस्ट कर गया.
हाँ, remaining west कर गया.
हाँ.
Over and above
भाई देखिए
114.
6 जमाबंदी
yes,
का
yes.
114
हाँ,
था.
got it, I got it.
इन दोनों को
6 में
माइनस
से हो
करके
गया
ये वेस्ट कर
114
गया.
हाँ, उतना वेस्ट करके और बाकी जो गवर्नमेंट का
ये लीजिए.
yes. That was only clarification.
Your Lordship may only allow me to, because in another put my.
हाँ नहीं आप जाइए. अब हम
मेरा problem.
आप अपने जूनियर को रखिएगा, उसको पता है क्या क्या हो रहा है यहाँ. Because he has been throughout in the board. हाँ बताइए.
First of all, Lordship, from the argument of 2nd of July 2025, Lordship. If Lordship will have that, it will be easier for Lordships to.
Yeah.
Since I am replying, order number 93, Lordship.
आपको उसको क्यों रिपीट करना है?
ये हम रिपीट नहीं कर रहे हैं. हमारा जो आर्गुमेंट था और इनका क्या रिप्लाई आया है
ऑर्डर नंबर 93.
93, Lordship.
सब सेंचुरी आप करा ही दीजिए.
नहीं नहीं.
एक और एक सेंचुरी वाला केस किए थे जो सुप्रीम कोर्ट में अभी चल रहा है. उसमें भी मिस्टर दास ही थे शायद.
I also remember one case Lordship had decided.
वही चल रहा है. 93
Lordship.
आपका चल रहा है ना सुप्रीम कोर्ट में अभी? हाँ? वो जजमेंट एडिशनल एविडेंस पे सब लोग साइट कर रहा है. पता है कि नहीं आपको? आपको खबर मिलते रहता है. लेकिन आई एम वेटिंग फॉर दैट जजमेंट. I'm also eagerly waiting
Lordship
for
is
that.
putting so much labor. They have the things in mind.
चलिए
Lordship.
बताइए.
The second point, Lordship, I'm just. It is on the point of non-joint of necessary.
हाँ.
Lordship, they have not given a single reply on the point of
Okay, no response.
no response. Very fast, I'll move, Lordship. No, Lordship. Point number 3. That is Exhibit 7, Lordship, by which Lordship the Deputy Commissioner has held that the M forms issued in favor of the Natas were null and void. Now, Exhibit 7, paragraph 10 is important, Lordship, which they are time again skipping.
Exhibit 7,
Para
para
10
10,
to be read in totality.
only para 10.
Only para 10. Lordship.
That their M form is also doubtful.
Yes, Lordship, and thereafter also. After that also. Just 3-4 lines are also. From the perusal of the endorsement, Lordship will kindly hear, Lordship will remember everything.
Yes, yes.
The order sheet of the record of the Court of Additional Collector Dhanbad, it appears that Jamamandi opened in the name of the petitioners. Petitioners means false in that case. that the Jamabandi opened in the name of petitioners are also not correct and beyond reasonable doubt, because Jamabandi has also been opened for Gair Majurwa Aam land, pawn, etc., violating provisions of the Act. Complete report has been submitted by the DCLR on 8/6/2006. Therefore, now Lordship, as per the report, DCLR, we have to ascertain whether Jamabandi to certain lands have been opened by violating the provisions of the section 5, 6 and 7 of the VLR Act or not, since this involves the interest of the state. Therefore, the state is added as the party in this case. Now thereafter, Lordship, nothing happened in this case. State were made party, and thereafter the subsequent proceeding of second opening of the Jamabandi, that was cancelled in the subsequent case. Therefore, Lordship, I was only submitting that paragraph 10 is very much important, in which, Lordship, the Deputy Commissioner, who is the head of the district and the custodian of the entire record, he comes to a finding that their Jamabandi is also not beyond suspicion, and I'll demonstrate how and what has been done in this case. The Lordship may point out that.
उसमें लिखे जाना rejoinder of the applicant. The learned counsel has submitted that the plaintiffs have not given any response on the point of non-joinder of necessary parties, which was raised by the applicant and reported in order dated 2/7/2025. He has further submitted that Exhibit 7, which has been referred to in paragraph 3 of order dated 2/7/2025, is to be read as a whole, particularly in the light of paragraph 10 thereof, wherein it has been mentioned that Jamabandi opened in the name of plaintiffs was not correct and was not beyond doubt. And in the state order itself, since the interest of the state was involved, the state was made party.
Four also, Lordship, relates to non-joinder party. Since, Lordship, on the fourth point,
यहाँ पर जो है एक सेकंड, non-joiner of necessary party para 2 लिखे हैं ना, 2 and 4 दोनों ऐड.
and it's 2 and 4. For paragraph 5, Lordship, they have still, in spite of our vehement opposition, that Form K as well as the proceeding under section 5, 6 and 7 has not been produced, in spite of the suspicion raised by the Deputy Commissioner and continuously argued by us, in spite of the given time by the Honorable Court, anything can be produced, certified copy, even during the hearing at the appellate stage. Nothing has been done.
The learned counsel for the appellant has also referred to paragraph 5 of the order dated 2/7/2025 to submit that Form K has not been produced at all, and therefore the plaintiffs have failed to
And the
prove their
proceeding
case.
of 5, 6 and 7 is also.
He has also
bottom line.
submitted that the proceeding of under section 5, 6 and 7, which has been under the Bihar Land Reforms Act, has also not been produced, which could have clarified the entire matter.
And any cloud on their suspicion could have been removed entirely.
Entire clarified.
Yes.
बताइए.
Now, Lordship, so far as Exhibit 5 is concerned, Lordship, that was filed by defendant number 5 to 10. That was, Lordship, order passed in the section 87 of the CNT. And we had, on the last occasion, I had shown that when the order passed in the section 87 of the CNT Act, there is a bar of section 58. On that point, Lordship, I am just submitting more. Because they have also not clarified, nothing has been argued on this point also.
He has submitted that no response has been given to the
3350 of 2002.
3350 of 2000.
Decided
फाइनल हो गया?
Decided on 6/7/2018.
6/7/18 ये फाइनल हो गया है?
हाँ. इसमें Lordship has.
इसका ऑर्डर निकालिए. WPC 3350 of 2002, dated 6/7/18. Number.
In this case, Lordship has decided that when the Deputy Commissioner passes an order, after the order of the circular officer, that too after many years. In this case also after 27 years, rightly and wrongly the order has been passed. But this relates to BLR Act and that belongs to we have maintenance and the courts.
नहीं आप समझे ही नहीं. अभी जब से ये बोर्ड बना है फर्स्ट अपील सेकंड अपील का
अच्छा.
मेरे साथ
Then
अभी
I'll
बहुत रिसेंटली डिसाइड किए हैं आपका इसी पॉइंट.
हम तब देखें, वो हमको नहीं.
भाई इतना हम आपको नहीं बता सकते हैं.
Not sure this is full bench judgment, the very celebrated judgment lordship on this one.
क्या नाम है बाकी का?
पारितोष माइती लordship.
इसी को डील करके क्यों?
हाँ, paragraph para 15.
हाँ.
May I?
Yes. बताइए.
Para 15 lordship is very important. The stage is now set for the consideration of section 258, which bars the suit in certain cases. What, however, deserves notice at this very outset is that even the section is not creating absolute bar to the jurisdiction against the civil courts, but only a conditional bar applicable in certain cases is specified there. If one may say so, it is a limited bar which would be elaborated hereinafter. What deserves pinpointing herein is that this section does not employ an unequivocal phraseology noticed earlier in section 57 of the Bihar and the Odisha Cooperative Societies Act or section 139(2) of this very act itself. It is true that it bars jurisdiction to any other court, including a civil court, to entertain a civil suit, but such prohibition is limited only to another suit either to vary, modify or set aside directly or indirectly any decision, order or decree of any deputy commissioner or revenue officer in a suit or application of proceeding under sections mentioned herein, including section 87. Thus, the precondition of the applicability of section 258 is the existence of an earlier order or a degree of a revenue officer or a deputy commissioner in a prior proceeding. From a refusal of this section, it is manifest. From the perusal of this section, it is manifest that if earlier any decision has been made by a revenue court in any suit under section 87, then only the other courts in the civil court have no jurisdiction to entertain any suit either to vary, modify or set aside the decision. It also makes it clear that the aforesaid decision or order will have the force or effect of a decree of a civil court in a suit between the parties. However, if there is no order or decision under the sections specified in section 258, including here in section 87, the jurisdiction of the civil court will not be barred, and especially so in a suit for declaration of a title and confirmation of possession or recovery of possession. What further calls for notice is that the fact that even when section 258 would not be attracted, the bar is not absolute. If the orders, decisions or the decree are challenged on the ground of fraud and want of jurisdiction, only these two grounds are required. Such a suit can still be entertained by a civil court. It would thus be manifest that sine qua non for the applicability of section 258 in present contest would be the existence of an order or a decree in a previous suit under section 87. Thus, if there has been no previous suit for the same list, no question of any varying, modifying or setting aside the same either directly or indirectly can arise. Thus, the absence of an earlier suit under section 87 in this context, the provisions of section 258 would not be applicable and attractive. Here, Lordship,
16
the true legal effect of a harmonious reading of section 87 and 258 may therefore be noticed. Chapter 12 provides of the record of rights of section 83. Herein deals with the preliminary publication, the amendment and the final publication of the records of right, whilst section 84 creates certain rebuttable presumption in favor of the correctness of the entries in the record of right. However, section 87 provides a remedy by way of a suit before a revenue officer for resolving any dispute with regard to such an entry in the record of rights or an omission therefrom. In essence, such a suit is thus directed as a challenge to the entry or omission in such a record. But section 87 further provides that this can be raised even where such a dispute with regard to the matters specified in clause A to F of section 87. In a way, therefore, section 87 provides a special and additional remedy pertaining to the entries in the revenue records as soon as they are finally published and certified. That is why the legislature has chosen to provide a narrow limitation of 3 months from the date of the certificate of the final publication of the record of rights for bringing such a suit. To my mind, this remedy is not in a way a derogation of the civil rights of a parties, but indeed it is a special and additional remedy which may be availed of within a limited period of 3 months if a party feels aggrieved by any of the entries in the records of rights. However, if such remedy is availed by the parties, then the statute now provides an appeal or even a second appeal to the High Court itself in a very forum of subsection 2 and section 87, which inevitably would achieve finality. Thus, if actual resort has been made to a suit under section 87, then for identical less section 258 would bar a further resort to a civil courts except on the grounds of fraud or want of jurisdiction. Obviously enough, to bring in even this limited bar, the list would have to be identical. However, as already noticed, and it bears repetition that if there is no resort has been earlier made to the suit under section 87 by the parties, the very precondition of the application of section 258 would be absent and it cannot come into play in such a situation.
What is the consequence of an adjudication under section 87?
Not sure.
It is only a presumption.
No, not presumption. What I am submitting.
Is it final?
It is final.
Section 87 निकालो. छोटा नाम बोल दीजिए. फिर नाम को tenancy.
Second appeal, it is not
Achha, wait.
382 of 2018.
क्या हुआ?
Lordship, which was asking, that is 382 of 2018.
382 of
2018.
second appeal.
Lordship. Decided on 27 to 25.
ये judgment दे दिया.
Amit Das was appearing in this case.
उनको तो याद ही नहीं है.
उनको याद.
ऐसे ही है. बहस करके भी भूल जाते हैं और जजमेंट लिख के भी भूल जाते हैं.
282 of 18.
इसमें हम इस इशू को डिसाइड किए. हमको याद है.
इसको देख.
ठीक.
The word Lordship starts. 387 Lordship. Institution of suits before revenue officer. In a proceeding under this chapter.
देखिए आप इसको री हियरिंग नहीं कर सकते हैं. ये जजमेंट आपने साइड पे नहीं किया था जब इन द केस पर
हमको तो देना ही है इसको, क्योंकि they have not controverted. तो हम बता दिए कि भाई जजमेंट भी मेरे फेवर में. That I have already argued.
हाँ तो जजमेंट तो आप प्लेस ही नहीं किए पहले, तो वो लोग कैसे रिस्पॉन्ड करते हैं आपके जजमेंट?
हम तो फैक्ट को प्लेस किए कि भाई 87 का है, 258 बार है.
लेकिन जजमेंट तो आपने नहीं प्लेस किया ना.
ये तो हुजूर तो हम कर ही सकते हैं, अभी भी कर सकते हैं.
नहीं कर ही सकते हैं, लेकिन जजमेंट अगर आप प्लेस करेंगे तो आप उनको रिपटल में तो जजमेंट.
हाँ, रिपटल लेना. फुल बेंच का जजमेंट, इसके बाद कोई जजमेंट नहीं आया.
ठीक है, हम लोग देखें.
हाँ, इसी में हुजूर नीचे दिया है कि सेकंड अपील भी होगा. फर्स्ट entirely decide like a suit Lordship, because appeal is decided by the district judge, and thereafter the second appeal is here. And in this case, Lordship, without degree, even the second appeal is because revenue court do not prepare degrees.
वो presumption of correctness कहाँ है?
वो 84 है Lordship. 84.
So if there is an institution of a suit before a revenue officer, that will be an institution of suit disputing the entry made in record of right.
पूरा 87 में पूरा है. It is vast, therefore it has been specifically paragraph 16 of the judgment Lordship that has been elaborated. E देखा जाए. As to any question relating to the title in land or to any interest in the land as between the parties to the suit, and as to any other matter also.
आपका section 87 वाला order का वो कौन सा?
That is exhibit 5 Lordship.
That is exhibit. ठीक है, ये तो आप लिखे हैं ना पंकज जी, Exhibit 5 के बारे में लिख लिया है।
हाँ लिखा हुआ, पैराग्राफ 7 में
The
लिखा
learned counsel has relied upon the judgment passed, full bench judgment of the Honorable Patna High Court in the case of Paritosh Methi versus Ghanshyam Methi, reported in AIR 1987, Patna 167, paragraph 15 and 16. ठीक है, और बताइए क्या छूट गया इनका?
Now and G4.
With respect to the argument of the plaintiffs that they were granted compensation, the learned counsel has submitted that Exhibit 9 was in favor of the plaintiffs, but compensation with respect to other land was also assessed in favor of the Dattas, while Exhibit G/2 to G/4.
Form के lordship I have stated, EC order I have stated lordship. Now about 3M forms. How lordship these 3M forms? Lordship has said that it was obtained from a LA case.
ये तो आप बहस कर चुके
नहीं
हैं, इतना
नहीं
लंबा
हम
बहस
बताएंगे ना
किया।
हुजूर,
हाँ,
एविडेंस एक्ट के तहत ये एग्जिबिट हुआ है कि नहीं, whether that is admissible in evidence or not. On that I
नहीं,
also give the
आपने
judgment.
तो बता ही दिया है
नहीं,
कि
नहीं।
वो अलग से बाद में
तो उस पे हम खाली जजमेंट दे देते हैं।
आप रिपीट मत करिए,
नहीं,
देखिए
हम
आप
तब हम
ऑडियंस के लिए मत बहस करिए, आप
नहीं,
हम नोट
audience-
कर लिए हैं।
तो उसे तीन सेक्शन
हाँ,
खाली नोट कर
हाँ
लिया।
बताइए सेक्शन।
एविडेंस एक्ट सेक्शन 65, 74, 76 and 79.
76 and 79
हाँ।
और सबमिशन बताइए, एक सेक्शन का सबमिशन।
हाँ बताओ।
65 के बारे में क्या बोलना है?
65 उसूल है। What is a
बताइए।
एक मिनट खाली खोल लेते हैं, गलत निकल जाए। Section 63 lordship deals with secondary evidence. 63 will not. It deals with secondary evidence. And 5, 4, 5, 6 points have been given. What are the secondary evidence? I am not dealing that lordship can see. Thereafter lordship 65. Cases in which secondary evidence relating to the documents may be given. E lordship. When an original is a public document within the meaning of section 74. Now section 74. What is a public document? Section 74 subclause 2 lordship will be important for this case. Public records kept in any state or private document of a private document. Any private document which is kept in a public record.
Public record of private document.
Yes. Here in lordship now section 76 comes into play. Certified copy of a public document. Every public officer, because I have to read this lordship. Every public officer having a custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of a legal fees thereof, together with a certificate written to the foot of such copy that it is a true copy of such a document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of the seal, and such copies so certified shall be called certified copies. Now explanation lordship is also important. Any officer by the ordinary course of official duty is authorized to deliver such copies shall be deemed to have the custody of such documents within the meaning of this section. Now lordship, it is an admitted fact that the M forms are in the revenue courts. That is, circle officer is the custodian of that document. what prevented them, even accepting and assuming that the original was, though it is required to be pleaded by them, I'll be placing judgments on that point also. Without any pleading that the original has been deposited on such and such place, we are producing these certified copies obtained from the original record. Now the original record is with the circle officer, the entire M forms. Till date, Lordship, the certified copies from the original records have not been brought on record. It is only in the LA cases from where some papers might have been submitted and the certified copy has been granted of those documents which were filed in that case for compensation fees. Therefore, in my humble submission, these certified copies which has been exhibited as M forms cannot be accepted as evidence to treat their right title and interest. On that point, Lordship, I'll be giving two judgments, Lordship. And section 79 is presumption, Lordship. Presumption of the genuineness of certified copies. All these points will be covering by these two judgments, Lordship.
The Judgment Council for the appellant has referred to section 63, 65, 74, 76 and 79 of the Evidence Act. He has submitted that section 63 deals with secondary evidence and 65 bracket E deals with public document. He has referred to section 74 within bracket 2 to submit that it deals with public record of private documents. And section 76 deals with certified copy of public documents. He submits that M form, that revenue courts are the custodian of M forms, and therefore the certified copy from the revenue reports could have been exhibited as secondary evidence. There was no question of exhibiting M forms obtained from another court, certified copy of M forms obtained from another court, and get them exhibited in the present case. He has submitted that certified copy of M form received from another court cannot be said to be a secondary evidence in rise of law, and therefore it could not have been admitted in evidence. This is over and above the fact that these M forms produced by the plaintiffs was never proved.
And one more thing. Also, Lordship, these M forms were obtained in the year 2008 and they were exhibited at the fag end of the trial in the year 2011.
वो तो हो गया.
क्यों वो किए हैं, क्यों वो क्यों बताएंगे इतना देरी क्यों की? Now, Lordship, one judgment I've just. That is 2007 volume 5.
He has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2007 bracket close 5 SSC 730.
Para 7 to 10 is.
Paragraph 7 to 10.
May I read that, Lordship?
किस पॉइंट पर है बताइए?
इसी पॉइंट पे secondary evidence. Secondary evidence as general rule is admissible only in the absence of primary evidence if the original itself is found to be inadmissible through failure of the party who files it to prove it to be valid. The same party is not entitled to introduce secondary evidence of its contents. Essentially, secondary evidence is evidence which may be given in the absence of the better evidence and which law requires to be first given. When the proper explanation, now it is important, when the proper explanation of its absence is given, they were only documents were just handed over to the court and that was marked an exhibit. The definition of 63 is exhaustive as the section declares the secondary evidence means and includes and then follow the 5 kinds of secondary evidence. The rule on which the most universal, namely that the best evidence of nature of the case will admit shall be produced, decides this objection. The rule only means that so long as the higher or the superior evidence is within your position or may be reached by you, you shall give no inferior proof in relation to it. Section 65 deals with the proof of the contents of the documents tendered in evidence. In order to enable a party to produce secondary evidence, it is necessary for a party to prove existence and execution of the original document. Under Section 64, documents are to be provided by primary evidence. Section 65, however, permits secondary evidence to be given of the existence, conditions, or contents documents under the circumstantial principles. The conditions laid down in the said section must be fulfilled before secondary evidence can be entered.
What else?
One word on this point. There are 10 to 14.
One more judgment. He has further relied upon judgment reported in bracket 2011, bracket close 4, SSC 240. Para numbers?
Para number 10 to 14.
Para 10 to 14.
And 17 also.
10 to 14 and 17.
Interestingly, Lordship, this also deals with the power of attorney. Both ways, Lordship will find it.
Same principle है ना?
हाँ, same principle है. हाँ, थोड़ा 17 important है.
Para number 10 to
17
14.
is the
10
two-
to 14 and 17.
हाँ, 11 to 14 and 17.
Sorry, 11 to 14 and 17.
17 से 2 लाइन का खाली हम पढ़ना. Therefore, it's the duty of the court to examine whether the documents produced in the court or contents thereof have any probative value. It's only 3 points. Now, other 2M forms are there, Lordship, since that is for an additional evidence. I'm not
The
asking
additional
on-
evidence with it. These very forms were subject matter of dispute between the parties,
Lordship.
between the Dattas and only these. So the fact that the informs were issued is not in dispute.
Lordship, what I am submitting. they will
No,
have-
I'm just
Lordship.
asking you
Yes.
that these very informs were subject matter of dispute between the plaintiffs and the Dattas. Correct? Because informs were issued even in favor of Dattas
Dattas.
and also in favor of the plaintiffs.
Yes.
And so they disputed, and there was a fight between both of them as to whose inform would survive. Ultimately, Datta's inform was cancelled, and their inform was held to be doubtful.
Therefore, why it was from here I want to proceed. Since the M forms, which they are saying, has been issued validly, that is the foremost question. Whether these M forms were issued validly or not. Therefore, Lordship, we have come with the additional evidence also that the Jamabandi in relation to the M forms have also been opened, and we'll give a comparative chart that all the Jamabandis is without the plot number except one of them. Lordship will have to look into all these things because this will determine the entire fact of the case and the conduct of the parties. I'll also come to the conduct of the plaintiff, and the Honorable Supreme Court has dealt heavily on
You
the.
see, please do not repeat your arguments. Whatever you are pointing out, we
I'm
are
not-
recording it.
Yes.
अब नया कहानी
हम नया
conduct
कुछ
पर
नहीं
मत-
बोल रहे हूँ, जो कंडक्ट पे हम बताए
जो
हैं,
आप जो उन्होंने आपको रिस्पॉन्ड किया है नहीं किया है वो आपने पॉइंट आउट कर दिया. जो उन्होंने रिस्पॉन्ड किया है उसके बारे में आप
let me complete in my own way. So I'll just take 2 minutes. No, Lordship, the power of attorney which was argued, I have examined the entire record. There is no power of attorney in record.
that you have already submitted.
The Dattas have submitted, Lordship.
That you have already submitted.
Yes, Lordship.
That has
And
already
without
been taken care
without power of attorney, the suit could not have proceeded.
of. वो हम लोग already कर चुके
ठीक. No, Lordship, one more judgment I'm just saying. I'm just giving judgments, Lordship, because I think Lordship.
on the same point.
No, different. On the burden of proof of the plaintiffs. 2014 volume 2.
इसमें कहाँ कोई डाउट है? Burden of proof तो plaintiff का है ही.
Yes, Lordship, since they are not even able to connect any of the documents,
वो
the,
ठीक है, वो आप
the
बोल
legal
चुके हैं ना
documents,
already.
legal
That is
documents.
why I put specific question to them.
Yes, Lordship.
कि भाई आपको आइडेंटिटी
I
आपको
vote on
अपना
that,
केस तो
yes.
प्रूव करना ही पड़ेगा.
Just Lordship, you record this. Para 19 and 20, Lordship, 2014 volume 2 SSC.
The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2014 bracket close to SCC 269 para 19 and 20 to submit that burden of proof is with the plaintiff to prove their case, which they have miserably failed.
Activity is also important.
1920 ठीक है और बताइए
2005 वर्जन 2000
एक ही चीज के लिए कितना जजमेंट
नहीं वही है उसका
हाँ तो बस हो गया
हाँ। एक कंडक्ट पे दे देते हैं
क्या चीज का कंडक्ट
नहीं,
कंडक्ट पे
conduct-
क्या
conduct-
ऐसा कंडक्ट पर आप
हम
बहस
उस
किए
10
देखिए
point-
आप इनिशियली कंडक्ट पे कोई बहस नहीं की
नहीं अभी तो हम बताएंगे
तो
ना
अब रिजॉइंडर पे क्या कंडक्ट पे बहस
दे
करेंगे
विल हैव द चांस
What
ये
chance?
तो अभी आइए बहस की है हुजूर जिस पे कभी करना नहीं था जिस पे हम लोग रेडी
नहीं
नहीं
नहीं कोई बात नहीं वो ठीक है कंडक्ट आइए तो हम आपको
दर्शक
सुनेंगे
खाली रिकॉर्ड कर
सर
दीजिए।
कंडक्ट इसका क्या चीज के लिए आप बहस कर रहे हैं
हम बता दें
रेलेवेंस बताइए कौन सा कंडक्ट पर आप बहस कर रहे हैं
5-6 पॉइंट्स
ऐसा नहीं हो सकता ना कि आप जो भी देंगे हम रिकॉर्ड करते जाएंगे
नहीं,
यू हैव टू शो द
Yes,
रेलेवेंस ऑफ द जजमेंट दैट यू
Yes,
आर
Lordship.
साइटिंग
फर्स्ट ऑफ ऑल दे हैव नॉट प्रूव्ड देयर कॉज ऑफ एक्शन
वो तो हो गया ना बात
Admitting-
cause of action
So
नहीं
that
है
is the conduct, Lordship. I'm just showing that they should come with a
that
proper
we have
conduct.
recorded and you are the appellant who did not even file a written statement
We have filed it.
Sahara's
The appellant number 3 has filed,
हाँ,
Lordship.
ठीक है
That can be my leg to them.
ठीक है
But they will
ना
have to overcome.
that's right we have recorded your submission
हाँ,
इससे
इसको
बात
तो
नहीं
खाली
है।
एक कंडक्ट पे ले लीजिए
क्या चीज पे किस
हम-
पॉइंट पे
हम
लिखे
तो-
बताइए
हम- Let me have 2 minutes. I'll just
हाँ,
cite out
what
the-
conduct
Yes,
are you
yes.
talking about you
If
just
not
tell
so-
me that this is the
हाँ,
conduct
yes, yes.
which is to be deprecated and then you cite the
Yes,
charge.
yes.
which conduct
एक एक करके उसको बोलेंगे 10 तो है अगर टाइम उसको दीजिएगा तो
10 कंडक्ट है
हाँ 10 कंडक्ट
जिस पे आपको ऑब्जेक्शन है
Yes.
बताइए कौन कौन सा कंडक्ट
First,
इसका
Lordship,
लिखते जाइए सब
हाँ.
का कंडक्ट हाँ बताइए Point one.
advertisement which has been pleaded in the plain. Lordship, आप लिखाइए उसको।
नहीं, आप ही लिखाइए।
नहीं हम
आप ही लिखाइए
नहीं, नहीं।
क्योंकि यू आर डिक्टेटिंग लिखाइए ऐसे नहीं
तो
होता है
उसमें
ना
हम
केस
बहस
इस
नहीं
तरह
करते
से
हैं।
नहीं होता है इस
तो
तरह से नहीं
तब
होता
उसमें बहस
है
नहीं
रिजॉइंडर में इस तरह से बहस नहीं
नहीं,
होता
नहीं, तो
प्लीज आपका जो भी चीज
we have
आपके
learned,
सामने
Lordship, कि
you see,
judgment हुजूर rejoinder पे
आपको
देते हैं।
बहुत पेशेंटली सुने हैं हर चीज हम सुने हैं ठीक है कोई चीज आपका छूटा नहीं है अब आप रिजॉइंडर में एक कंडक्ट का नया कहानी शुरू करेंगे तो सबका
We have
कहानी शुरू हो
already
जाए।
starting point मेरा conduct ही था।
हाँ तो जो पैराग्राफ था वो दिखा दीजिए और उसका बोल दीजिए कि इन्होंने कोई रिस्पांस नहीं दिया
नहीं,
That
नहीं,
is all.
The first day, Lordship,
उसका
I-
उन्होंने respond
when-
किया है।
When
You
I
see,
when I started
know.
my argument from
Yes,
the plaint,
cause of
I
action
said
नहीं आया हुआ है।
नहीं उसके बाद हुजूर बताया कि initially the Datta should have been made party and that is the
ठीक है,
first
बाद में-
conduct.
ठीक है बाद में तो इसको दत्ता पार्टी बन
और
गए ना
हुजूर हम बताएंगे ना कि क्या क्या
ऐसे
इनका
नहीं होता है।
how
Mr.
how
Vishal
they have
Tiwari, please
tried
do
to
not please do not take the case court for a right
Lordship,
आप
how
हमको
they
बता
have
दीजिए
tried to mislead the court, Lordship,
tell
that
us.
is only my
No, just tell us कौन से ऑर्डर का कौन सा पैराग्राफ आप रेफर कर रहे हैं ऑन द पॉइंट ऑफ कंडक्ट आप बता दीजिए
Lordship,
आप
from
हमको
the entire
आपका एक
case.
एक चीज
I'm sorry,
देखिए आपको री हियरिंग का हम आपको
from
मौका
just
देंगे, सर।
4 point हुजूर सुन लिया
क्या 4 पॉइंट सुन ही रहे हैं ना इतना दिन से रिजॉइंडर में इतना बहस नहीं होता है इन्होंने जो नहीं रिस्पॉन्ड किया है आई रिकॉर्डेड
Lordship,
जो इन्होंने
can
रिस्पॉन्ड
only
किया है
record.
आप-
हम हुजूर बहस नहीं करते एक जजमेंट देने खाली इसको रिकॉर्ड
नहीं। The learned counsel for the appellant has submitted that has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2005 bracket close 2 SCC 217 para 16 and has submitted that the conduct of the plaintiff has not been proper but so far as the conduct is concerned at the time of initial argument he has referred to the fact that the cause of action was not proved, that plea has been responded to by the plaintiffs, and therefore this court prima facie feels that this judgment has no relevance.
And Lordship, why the Haribol has not been made party?
But that has already been taken care of.
Yes, yes.
भाई आपने बोला non-joined, they have not responded.
Yes.
बात खत्म हो गया. They have not responded. तो अब क्या बचा है? They accept.
एक 105 पे बहस किए थे उसी खाली जजमेंट
किसका?
किया 105 पे बहस किए थे
105
सीपीसी
CPC पर that you have to specifically challenge.
हाँ उसका वैसा कुछ नहीं है दैट इज पैराग्राफ कितना है पैराग्राफ 10
Right.
इसको खाली
With respect to the arguments advanced by the plaintiffs in connection with section 105 of CPC, that the interlocutory orders is required to be specifically challenged, The learned counsel has referred to the judgment passed by the Honorable Supreme Court reported in 1995, supplementary within bracket 4 SSC 455. Para number?
10 Lordship. 10.
Para 10. And submits that once the appeal is filed by the defendants against the decree of the trial court, he is entitled to challenge the correctness of any interlocutory order passed in the suit in such appeal by virtue of section 105 of CPC.
Which has not been appealed separately in
It is not necessary in such a case that he should prefer an independent appeal against the order dismissing an interlocutory application, even if it is appealable.
No.
Yes.
Yes.
और कुछ बचा?
नहीं.
The learned counsel for the parties have jointly submitted that they will prepare their short synopsis of arguments based on their arguments which has been advanced during the course of hearing, and they would also confine their arguments to the judgments which has been cited before this court during the course of hearing. नया कहानी नहीं सुनी.
नहीं नया नहीं लेकिन few judgments proper adjudication के लिए.
क्या इसका क्या मतलब है प्रॉपर?
अच्छा,
इतना आप लोग को मौका दिए हैं जजमेंट साइड
only
करने
assisting
के लिए.
it.
ऐसे थोड़ी होता है. हम भी आपको एसएससी ऑनलाइन का पेन ड्राइव पूरा थमा देंगे, पढ़ते रहिएगा बैठ के. ऐसे नहीं. Things which you do not cite, things which you do not place, we will not take care. आप कर लीजिए. ठीक है. The needful will be done by Friday.
No.
Post on Tuesday. On next Tuesday, the arguments will be advanced so far as the interlocutory applications are concerned. ठीक है? जितना आइए है ना, सुन रहे हैं? जितना आइए है सब अलग करेंगे, जो पेंडिंग आइए है सब अलग करेंगे. उसमें जो जो रिस्पॉन्स आया हुआ है उसी आइए के नीचे लगा देंगे सब, और उसका बंडल बिल्कुल अलग कर देंगे.
आइए विद रिजॉइंडर.
हाँ, जो भी रिजॉइंडर काउंटर.
Your Lordship, then I'll be adding one more judgment.
हाँ, बता दीजिए जजमेंट आपको कौन सा.
2004 volume 7 SCC, 2004 volume 7 SCC,
2004
volume 7 SCC, page 107.
107.
This is with regard to whenever there is an objection with regard to marking of a document, the mode of and manner of proof, then a person has to challenge it at the time of marking itself, and subsequently he cannot. So, if had it been their case that the document itself was absolutely inadmissible in evidence, then the matter would be different. But here, their whole objection is that the manner in which it was required to be proved, that has not. This judgment says that it has to be objected at the time of marking it.
इन्होंने बोला है कि वो एक मिसमैच बताया ना,
हाँ,
जो
mismatch
शीट
पता है,
में है,
but order sheet would prevail.
ऑर्डर शीट में नहीं है. दूसरा, वो जब मार्क हुआ है उस समय ऑब्जेक्शन के साथ मार्क नहीं हुआ है. जो उस समय जो मार्क होता है, जिसे एग्जिबिट मार्क जो होता है, उसमें भी तो ऑब्जेक्शन लिखाता है नॉर्मली. आई डू नॉट नो इसमें बाकी सब डॉक्यूमेंट्स में कैसे लिखा है, लेकिन उसमें भी लिखाता है. कोई भी डॉक्यूमेंट मार्क होता है, ब्रैकेट में लिखाता है विद ऑब्जेक्शन, उस वक्त लिखाता है विद ऑब्जेक्शन. ऐसा नहीं है कि नहीं.
हाँ, यही हम कह रहे हैं कि जो 2011 में सुप्रीम कोर्ट दिए है ना, पैराग्राफ 17, इट डील्स विद एवरीथिंग.
ठीक.
वो मार्क नहीं होने से क्या होगा, होने से क्या होगा.
का जहाँ पे ये प्लेंटिव्स का जहाँ आर्गुमेंट हुआ है, he has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2004 bracket close 7 SCC 107 to submit that objection with regard to marking of documents and its proof.
Mode and manner of proof.
And mode and manner of proof is required to be taken at the threshold.
Only we have when we
and
have a
such an
chance.
objection cannot be raised subsequently.
Only when Lordship the other person has a chance.
Only one thing we will mention, that while preparing the written notes, while we were making submissions, I had also at the very outset said that I will not repeat what my learned friend has already argued. But in the notes to maintain the flow, I have to mention.
You see, since you are in the same
Yes,
boat, you can give a joint written submission. What is the big deal about it? आप लोग दोनों jointly दे दीजिए. You are supporting each other.
Supporting each other, लेकिन jointly दे सकेंगे कि नहीं? I do not know.
वो आप जानिए आपको क्या करना. You can simply say that whatever submissions was argued by them, you adopted, and then you have in furtherance you have made these submissions. यही है आपका, because this is what you did.
Facts का अगर देते तो लॉटरी it would have been easy.
एक flow में मतलब?
अच्छा जैसे प्लेंट का कुछ बात, जब प्लेंट का हम भी कुछ आर्गुमेंट किए, ये भी कुछ आर्गुमेंट. जब प्लेंट को डिस्कस कर रहे रिटर्न नोट्स में, तो प्लेंट का
देखिए वो जितना भी बहस किए हैं सब रिकॉर्डेड है. आपको जो भी आपने भी जो बहस किया सब रिकॉर्डेड है. तो आप अपना रिटन नोट्स में यू कैन जस्ट से दैट यू अडॉप्ट ऑल द आर्गुमेंट्स एडवांस बाय देम एंड इन एडिशन हैव टू से दिस. बस हो गया बात खत्म. उनको वापस Tuesday 2:15. I pass over to you.
Passover case.
Mr. Banerjee, your case is there. Argue your case. Your case has been called out. Argue. कोई बात नहीं.
Serial 21.
हाँ.
Serial 21.
The serial 2 of daily list.
Serial 2.
Mr. Bajaj, I'm sorry. कल दिखाते हैं. ठीक है? कल दिखाते हैं.
I have also asked the council on record to be present tomorrow.
No, I do not know. इसका क्या मतलब है? Council on record to
He
be.
is also going to be present. There is a hearing tomorrow.
कल कोई hearing नहीं है. कल हम अपना judgment लिखाएंगे. उनका appearance हम इस तरह से argument में नहीं record कर सकते.
Appearance.
तो फिर किस?
Just to be present.
Being a different present, we don't bother about it.
Each may have to take liberty and excuse.
देखिए जरा. ये first appeal number 118 of 2023. The learned counsel for the appellant. नाम बताइए अपना.
Paramveer Singh
Mr. Paramveer Singh
Bajaj.
Bajaj has advanced his arguments today and has concluded his arguments. Nobody has entered appearance on behalf of respondent in spite of repeated opportunities. Pose this case for dictation tomorrow. हो गया? बस अब किसी का कोई काम नहीं.
कोई काम बस पता है. I should be present tomorrow.
You should be present to assist कि कोई गलती नहीं हो जाए.
Absolutely.
लेकिन बाकी advocate on record नहीं आया है, we don't bother.
नहीं absolutely. कल एक
Ornamental appearance यहाँ किसी का नहीं.
not at all. I'm just saying tomorrow थोड़ा maybe excuse बीच में हो सकता है कहीं.
नहीं आइएगा तो नहीं दिखाएंगे. आप बताइए कब आप परसों आ सकते हैं? परसों कर दीजिएगा.
नहीं कल.
Day after tomorrow. परसों. Day after tomorrow at 2:15. Is that okay? Are you comfortable? Mr. Bajaj.
Yes.
Are you comfortable? आप इतना अच्छा बहस किए क्यों परेशान हो रहे हैं? आपके सामने दिखाना चाहते हैं? बता दीजिए.
Tomorrow is fine in revision. Tomorrow is fine. 2:15.
Fair enough?
Yes.
ठीक. 2:15 बजे. आइटम 3 में क्या था? एजेंट. आइटम 3 कॉल करें.
Item 3 FA 298 of
किसको चाहिए?
2023.
टुमारो चाहिए था.
हो जाता तो कर निकलेंगे. अभी तो इतना
भूल गए क्या था ये.
ये लैंड एक्विजिशन वाला है.
हाँ लैंड एक्विजिशन अदर साइड कहाँ
सर्कुलेट जो ये जो
हाँ कहाँ है अदर साइड
आई नहीं हम समझते
First appeal number 298 of 2023. Counsel for the appellant is present. Counsel for the respondent is absent. Postmortem. चलिए कल आइएगा करने ठीक है एग्जिबिट वो जो है ना एग्जिबिट थोड़ा मार्क कर फ्लैग कर देंगे इनको फ्लैग दीजिए सर हाँ एडमिशन का 2 केस है ना करिए
And reading for admission, item 11, FA 199 of 2023.
आप हैं इसमें एडमिशन मैटर में जस्ट होल्ड ऑन ये एडमिट करने के लिए फॉर्मल एडमिशन होता है फर्स्ट अपील है इसको कर लें ठीक है जस्ट प्लीज होल्ड ऑन फॉर admit issue notice to the respondents for which requisites be filed under ordinary process within a period of 2 weeks from today. Let the records be called for from the concerned court. Yeah, we are admitting this case. Are you there in this case?
Yes, Your Lordship. I am for the appellants, Your Lordship, for the appellant.
आपकी lunch का appearance. Give your appearance आप online आप कर दीजिए.
Obliged, obliged.
2 weeks for issuance of notice under ordinary process. You file it. Pose this case on 22nd September. Awaiting service report.
Obliged, Your Lordship.
Communicate कर दीजिए. LCR to be called. और बताइए कौन सा?
Item 12, FA 57 of
Just
2025.
Who is there in this case? Appellant. Yes. Appellant is present. Is somebody joining? Admit. Call for LCR. Let notice be issued to the respondents for which requisites be filed within a period of 2 weeks from today. Ordinary process. Same data, we are waiting service report. Since the appellant is absent, let a soft copy of this order be forwarded to the counsel for the appellant for compliance. Orders चाहिए. इनका एक 21 इन्होंने out of turn mention किया था ना? Yes. This was mentioned out of turn. On the last occasion also, it was agreed that it will be taken up.
Yes, we are ready.
You start with that.
Item 21, second appeal 153 of 2018.
Yes. Yes, please.
Initially, my lord.
पूरा आप टाइमलाइन दीजिए. टाइटल सूट से लेकर हर डेट आप उनको बताइए, ठीक है? बताइए.
Gulam Subhani was the initial plaintiff, my lord. He filed an eviction suit number 10 of 1996 on 10/7/1996.
Just
11/7/1996.
eviction suit number
10 of 1996
10 of 1996
filed on
filed on
11/7/1996.
11/7/1996. Yes.
Subsequently, date is 11/7/1996. Defendant filed an affidavit for leave to contest, which was allowed without any objection, and the suit was fixed for hearing on 21/8/1996.
Leave to contest,
Yes, madam.
which was filed on
No, that date is not there, but the date was fixed for hearing on 21st of.
on the leave to contest.
No. Upon the leave to contest, that is not on the record.
It was granted.
Right. And date fixed was 21/8/1996.
21/8/1996. For what purpose?
For hearing, this was the eviction suit, my lord.
Yes.
One Naam Subhani, who is the opposite party in this case, he was the original plaintiff in the eviction suit, and Ghulam Subhani.
Ghulam Subhani,
Yes, ma'am.
respondent number 1,
Yes, ma'am.
is the original plaintiff.
Plaintiff. He filed an eviction suit against Jagdish Bhuiya.
In title suit.
Yes, my lord.
Okay. Eviction suit against
Jagdish Bhuiya,
Jagdish Bhuiya.
whom he presumed to be his tenant.
Okay. Then Jagdish Bhuiya filed a petition for leave to appeal that. Leave to contest.
Yes, madam. And the date was fixed on 21/8/1996 for hearing. Now, my lord, decree and judgment was passed on 30th of that month only, 30/8/1996. 30/08/1996.
30/08/1996. Judgment.
Yes, my lord. Meaning thereby, my lord, that on July 1996, eviction suit was filed, and on 30th of 8/1996, within a period of 1 month, the decree, 1 month 20 days, decree was passed of eviction.
Is there any legal bar? जल्दी से केस नहीं कर सकते.
No, not at all. Order 5 has to be followed, that's it. Then, my lord, the decree holder on 1st of May 1997, 5/1997,
Decree holder did what?
he filed an execution case, my lord.
Execution case.
That
Then
is
what happened?
7th of 1997.
1/5/97.
That is the date, and the execution case number is 7 of 1997.
7 of 1997. Execution case.
Yes, madam.
Okay.
Then, my lord, on 9/6/1997,
9/6/1997. What happened?
application was filed on behalf of judgment debtor, that is Jagdish Bhuiya.
File application under
He filed an objection, but
Objection.
that was also again not pressed
objection under
against the execution case.
yes, okay. Under which section?
But execution is already has been filed under order 2021. When the notices have been served to him for execution, he filed just an objection,
Okay.
and in that objection itself, subsequently he not pressed the objection.
Not pressed. Then what happened?
Then, my lord, the next date was fixed on 21/6/1997. That's the date of hearing. And on 1/6/1997, the applicant, who is the objectionist in this case, who is the appellant, filed an miss case. This miss case number 7 of 1997.
Yes.
Then, my lord, on 9/4,
This miscellaneous case was filed under which section?
Order 21, Rule 97.
How is this appellant connected with the suit property? What is the connection of this appellant with the suit property?
He has got the sale deed executed, my lord, from the true owners of the property
The appellant claims the property. Just a moment.
through a sale deed.
Properties through sale deed.
Yes, ma'am.
Sale deed number?
That is, my lord. I have jotted in the
डेट बता दीजिए. Registered sale deed.
yes, yes, yes.
डेट बताइए.
Yes. 16/11/96.
16/11/96. Executed by?
By the true owners of the property.
Who are the two owners?
They are, my lord, Aarti Das,
Aarti Das. Wife of? Exhibit number बताइए.
exhibit number 9, my lord.
Exhibit 9. Aarti Das and others, right?
Yes, my lord.
They are not related to the dignity holder.
No.
Not related to. Yes.
And the decree holder, he is claiming right title interest by virtue of a sale deed that is executed by a power of attorney holder.
Of the same vendor.
Yes, as per them.
Power of attorney का डेट बताइए.
Sale deed का date
Power
होगा,
of attorney का डेट.
that has not been executed.
फिर भी होगा ना सेल डीड में पावर ऑफ अटॉर्नी.
27/5/1993.
27/5/1993.
Registered power part.
रजिस्टर्ड पावर ऑफ अटॉर्नी. और उनका सेल डीड का डेट बताइए.
उनका सेल डीड है एग्जिबिट ए, सेल डीड नंबर है 12397.
डेट बताइए.
डेट है 28/9/1995.
28/9.
August
28/8/1995.
1995. There is a mistake, my lord, in my written arguments. Para 5.
28
9.
8 करते हैं.
Yes.
ठीक. Okay. So they are the owners of the property by virtue of an earlier sale deed executed by a registered power of attorney holder. So the property that you are claiming by virtue of a subsequent sale deed, by that time the property was already sold.
Not legal.
What do you mean not legal?
May I just appraise your lordship with certain. May I come to the plaint first, if your lordship allow?
Plaint में कहाँ जा रहे हैं?
Then वहाँ पे
Miscellaneous case में आपका you are not a party to the plaint.
no.
You are not a party to the suit.
Memo of application. Memo of this application.
नहीं आप हमको पहले बताइए ना, हम आपका सब कहानी सुनेंगे. आप हमको ये जो सीक्वेंस बता रहे इसको कंप्लीट करिए. आपका मेन पॉइंट क्या है?
Main point यही है कि the sale deed which was executed through a power of attorney, they have filed an eviction suit. By virtue of that only, they have filed an eviction suit against Jagdish Bhumia. They got a decree of eviction, then they filed an execution. This is the chronology of the dates. Now my lord will come to fact that I have filed a separate title suit and that has been pleaded in my memo of application order 21/2/97, that at para 5 that the vendors have issued a title suit number 37 of 1997. These vendors in the court of subject such and such and such.
Which vendor has done it? The decree holder?
No. The original vendors, I mean the original owners of the property, with the objection is they have filed a separate suit. That is suit number 37 of 1997. That has been pleaded in my para 5.
Vendor has filed suit.
With
1 second. Filed suit. Number?
37 of 97.
37 of 97.
With the appellant. They were plaintiff.
With the? Against the?
Against this Ghulam Subhani.
The vendor of the plaintiff has filed a suit against the?
Against Ghulam Subhani, who is the subsequent purchaser. Liaq Ahmad.
Vendors of the plaintiff had filed a suit against the plaintiff. Correct?
Vendors of the, no.
Ghulam
We can
Suhani
say-
is the original plaintiff.
Yes, we can say like this, that the true owners of the property
True,
initially,
who is the true owner of the property?
they are
Das.
Aarti Das,
Yes.
Sudipta Das,
Yes.
then Sanjogta
So they
Das,
have, yes, they have filed a suit against whom?
against Ghulam Subhani,
Who
original
is-
plaintiff. Original plaintiff.
Yahi na?
Yes.
Vendors of plaintiff
With the appellant, present appellant.
has filed suit number this against the plaintiff, and the present appellant is the co-plaintiff
In 37.
in 37 of 97.
Yes, and he is plaintiff number 4.
Co-plaintiff.
Yes.
Number 4.
Now, before initiation of this proceeding under section 21 under order 21/97, we have filed a separate suit. My lord. We have appraised the trial, means the execution court, that there is already a suit pending.
Which suit have you filed? 37 of 97.
Yes, this suit was basically for right title interest and set asiding the sale deeds, my lord.
Sale deed in favor of the plaintiff.
Yes, this Liaq Ahmed, the power of attorney holder, who has executed the sale deed in favor of Ghulam Subhani, the relief of that case, 3797, the first relief is the all sale deeds which has been executed through power of attorney may be set aside. So when there was a cloud in my title, I got a title from the two owners, they got a title through, there was a power of attorney as a middleman. So there was a cloud in my title. So first thing what I should do is I should file a title suit. So I filed a title suit. Now in that title suit there is a specific relief which I have claimed, that is these sale deeds executed by through power of attorney is what I have been issued is illegal. That that fact, my lord, I have appraised before the execution court, as it is evident from my memo of application, my lord. Para number 5.
The learned counsel for the appellant has submitted that eviction suit number 10 of 1996 was filed by the original plaintiff, who is the respondent in the present case. The suit was filed against Jagdish Bhutia, Jagdish Bhuiya, who was a tenant, and it was filed on 11/7/1996. Jagdish Bhuiya filed a petition seeking leave to contest, and ultimately the suit was fixed for hearing on 21/8/1996 and was decreed on 30/8/1996. He submits that a total period of 1 month 20 days was taken for the learned trial court to decree the suit. Thereafter, on 1/5/1997, the decree holder filed execution case which was numbered as execution case number 7 of 1997. The judgment debtor Jagdish Bhuiya filed an objection in the execution case on 9/6/1997, but the objection was not pressed. Thereafter, the appellant had filed a petition under Order 21 Rule 97 of CPC on 21/6/1997, which was numbered as miscellaneous case number 7 of 1997. And in the miscellaneous case, the appellant claimed that he has purchased the property by virtue of registered sale deed dated 16/11/1996 executed by the true owner of the property. The learned counsel submits that so far as the original plaintiff is concerned, he is claiming the property by virtue of registered sale deed with respect to the same property dated registered sale deed dated 28/8/1995 with respect to the same property, which was executed by the power of attorney holder of the original vendor, and the power of attorney is dated 27/5/1993. The learned counsel submits that although the power of attorney as well as the sale deed of the plaintiff is prior in point of time as compared to the sale deed of the plaintiff executed by the original owner of the property, but another suit has been filed by the vendors of the plaintiff bearing title suit number 37 of 1997, in which the present appellant is plaintiff number 4. Thus, the original vendor of the property and the present appellant have joined together to file title suit number 37 of 1997, seeking a prayer to set aside the sale deed executed. Means various sale deeds executed by power of attorney holder, including the sale deed which was executed in favor of the original plaintiff of the present case, which was dated 28/8/1995. यही है कहानी। तो आपका क्या चल रहा है सूट में?
We have won the suit.
What is it? You
Set
have won the
aside.
suit.
Yes, that
The sale deed has been set aside.
We have won the appeal also. Appeal has also been confirmed, madam.
कहाँ है judgment?
Those I have filed in a IA. Those are on record, but these are not certified copies. But a true copy. Only point of consideration, my lord, Rule 104.
The learned counsel has submitted that the title suit number 37 of 1997 has been decided in favor of the present appellant, who is the co-plaintiff along with the original vendor of the property, and the same has been decided by judgment dated
30th of May 2019.
35/2019, which has been placed on record through interlocutory application.
Yes.
And appeal against the same has also been dismissed.
Yes.
In title appeal number?
Title appeal number is 57 of 2019.
Title appeal number 57 of 2019, which has also been placed on record through the interlocutory application.
And the judgment dated 10/4/2024.
And the judgment in the title appeal is dated 10/4/2024.
2024.
The learned counsel submits that the entire basis of the claim of the original plaintiff, that is his sale deed dated 28/8/1995, has been set aside, and therefore the plaintiff, who has filed the execution case has no right title interest over the property. And under such circumstances, the objection filed by the appellant ought to have been allowed. यही आपका total case. जब वहाँ पेंडिंग था तब तो ये सब नहीं डिसाइड हुआ होगा ना? तो ये कब डिसाइड हुआ है? कब? 2018 से चल रहा है?
अपील, यस, अपील.
मतलब कितना भी चलाते हैं?
अपील 18 से.
This judgment has attained finality, Mr. Das. Sorry,
Yes,
Mr. Banerjee.
Second appeal is pending. We have
Stay?
filed. Yes.
Stay?
Stay is not there. Second appeal 154 of 24. Notices has been issued in limitation matter.
Second appeal number
154 of
154 of
2024.
2024.
So the matter is
Just a moment. Second appeal number 154 of 2024. Substantial question of law has been framed.
No, it is only
The
notice. Notices has been issued.
कौन
in
सा
limit-
court issue किया है this?
Notices are issued by Honorable Court number 60.
24 second appeal मेरे पास है. 23 तक.
24 is present here.
तो अभी तो वो जजमेंट आपका सेटिसाइड नहीं हुआ है, कुछ भी नहीं हुआ है. लिमिटेशन पे चल रहा है. The learned counsel for the respondent has submitted that a second appeal number 154 of 2024 has been filed against the dismissal of appeal arising out of title suit number 37 of 1997, in which notices has been issued in the on the point of limitation, but no substantial question of law as such has been framed. आप appear कर गए उसमें?
I have to see, madam. Tomorrow I'll give it. I have to see. And one
दिखाई
more.
जरा. Second appeal number 154 of 2024 का status बताइए. 154 of 2024.
Appeared, madam.
तब इसमें कैसे आपको रिलीफ दें बताइए.
I'll just. There is one more provision.
इस बोर्ड में होता तो दोनों साथ ही सुनते.
Yes, appeared. So there is one more provision. That is also substantial question of law, my lord. Order under 104, my lord, which says that every order made under Rule 101 or Rule 103 shall be subject to the result of any suit that may be pending on the date of commencement of the proceeding in which such order is made. If in such suit the party against whom the order under Rule 101 or Rule 103 is made has sought to establish a right which he claims to present possession of the property. Now suppose, my lord, this miscellaneous case would have, I would have succeeded in this case, and the title suit which I have filed, that is 3797, I would have lost that case. So by virtue of my losing that case, this judgment, if at all it would be in my favor, will go to nullity, my lord. And conversely, it is applicable. If I lose this case, so it is always to this subject to the outcome of that case. Now, my lord, two judgments
Are you in possession of the property?
Yes. Yes, ma'am. That may be recorded.
Are they in possession of the property?
We have disputed that we have said that Jagdish.
You are who?
We are the purchasers of that property.
That's
So-
right. So admittedly, you are not in possession.
No, therefore we filed that eviction suit.
Right.
Except two rooms. Except two
That's
rooms.
right. But you are not in possession of the property.
Except two rooms.
Admittedly.
Yes, our case is that except two rooms,
Yes.
we are not in possession. Except two rooms, the Jagdish Bhaiya is in possession. Rest we are in possession.
There is no more, sir.
That whatever.
That's right. Right. Whatever it is, so far as the suit property is concerned, you are not in possession of the property.
So
Right.
far as the eviction The schedule of the
that's right.
eviction suit
That's
is
right.
concerned.
Now third party is in possession of the property.
So far the suit of property, scheduled property of the eviction suit is concerned, we are not in possession. Except that we are in possession.
आपका कोई stay petition लगा हुआ है ना? ठीक
Yes,
है? हाँ. Considering
That stay petition has been disposed of.
No, we will take care of that.
That has been
Considering the aforesaid circumstances, this court is of the considered view that
Uh,
the decision of the present appeal should await the final decision of SA number 154 of 2024. Faced with this situation, the further proceedings in
May
the
I just,
execution
make
case
certain
shall remain
submissions?
stayed.
May I make certain submissions? Now, so far as the Order 21 Rule 97 on the stay application, Order 21 Rule 97 application, when it was filed, at that point of time or when it was decided finally,
The interim order shall continue.
the stay application
Just
has
a
already been
moment.
disposed of.
Yes, may be disposed of. So what? We are hearing in the midst of the hearing, and it is an admitted fact that your title.
Therefore, I am praying. Therefore, I am
Therefore,
praying one thing. I am praying. It can be taken in this way. I am just making a submission. Final order will be by this court. I may be allowed to make a submission. I am just making a submission that the suit has been decided against me. Appeal has been decided against me, but it has not attained finality.
No substantial question of law has been framed in the second appeal.
The appeal, it doesn't mean even if the
It means that only unless the substantial question of law is
I may be
framed, the
just allowed
suit is
to.
not.
I may be just allowed to make the submissions. It doesn't mean if a substantial question of law has not been framed. It doesn't mean that the appeal is not there. Appeal is in existence.
Okay.
The appeal is in existence. Notices are issued in limitation, and so appeal is continuation of a suit.
That's right.
What Code of Civil Procedure statutes recognizes.
That's right.
Now this judgment and decree in the suit has not attained finality. It is still sub judice.
That's right.
Now therefore a decree, a properly contested suit and a decree by a competent civil court, that decree in the eviction suit has attained finality. That decree was sought to be executed and it has been almost executed. The decree was issued. And they at that fag end they turned up and they filed an application under Order 21 Rule 97. Until the Order 21 Rule 97 application was decided or the miscellaneous appeal was decided, the suit was not decided. The proceedings of the judgment and decree of the suit was not there on record in the proceedings of the Order 21 Rule 97 or in the impugned miscellaneous appeal. It was not there. And the most important aspect of the matter, our submission is that the title suit 37 of 97, it is yet to attain finality, so that decree cannot be considered.
Don't repeat your argument. I have heard you.
So that decree cannot be considered.
4:45 argument repeat करने का कोई जरूरत नहीं. हम note कर लिया. हम आपको उसको लिखाएंगे अभी.
So that decree cannot be considered for the purpose of extending any interim
That's
order, because the fruits of a decree,
That's
a decree holder cannot be denied fruits of a decree.
That's right.
There is now the registered cell deed which we have got. There is no denial of the fact that the registered power of attorney is there. The principle of power of attorney, they do not deny the execution of the power of attorney.
And अभी interlocutory stage में final नहीं सुन रहे ना.
And their
लिखिए जरा.
their cell deed
एक
executed.
second. The learned counsel for the appellant has submitted that either that since the second appeal arising out of title suit number 37 of 1997 has not yet been admitted and no substantial question of law has been framed. Therefore, the execution cannot proceed as the title of the plaintiff does not survive anymore, and therefore the appellant cannot be evicted in the execution case. However, he has also submitted that there could be another option, that this matter be placed after the disposal of second appeal number 154 of 2024, in which the present appellant has already entered appearance and he undertakes to cooperate with the early disposal of the second appeal. He has also submitted that the further proceeding as against that there is already an interim order with regard to stay of further proceeding in the execution case, the same may be extended. The counsel for the respondent has opposed the prayer and has submitted that the second appeal is pending and therefore the suit itself is pending, as second appeal is a continuation of suit. However, he does not dispute that in the second appeal, notice has been issued on the point of limitation and consequently no substantial question of law has been framed. Considering the totality of facts and circumstances, this court is of the considered view that the present case should be heard after disposal of second appeal number 154 of 2024, and accordingly the matter is adjourned and is directed to be posted on 22nd of September. Till 22nd of September, the interim order already granted by this court shall continue. Let this order be communicated.
Our objections may kindly be recorded.
I have recorded your objection.
Because we are only saying that Order 21, Rule 97, there is no error or perversity in the proceedings.
Right. The
The court
learned
has-
counsel has submitted that so far as the impugned judgment is concerned, there is no error. And but however, during the course of hearing, it is not in dispute that subsequent developments have taken place.
which were not on record
Just a
in those
moment.
proceedings.
Subsequent development has taken place during the pendency of the present appeal.
Which were not on record.
Naturally, it cannot be on record, Mr. Banerjee.
Therefore, there is no fault with
That
those
is sufficient.
proceedings. That is also.